122810 Kelly Rowe versus Phillips County Hospital. The parties are aware of this, but to let those who are watching our oral arguments today know that Justice Wall is recused. As you see, he's left the courtroom, and he will not participate in this argument, nor will he participate in the conferencing of the case or in making of it.
Thank you, Your Honors. May it please the court. Max Couch of Couch Law LLC on for Kelly Rowe, the plaintiff appellant in this matter. I would request 2 minutes to reserve 2 minutes for rebuttal. Your Honors, the plaintiff in this case, my client, is asking you to find that under the KORA, the Kansas Open Records Act, a public agency is obligated to produce records in the format of the requester's choice, so long as the agency has the capability of producing the requested record in that format. Here, it is undisputed that the public agency is capable of producing the record in that format. So that factual issue is not an issue.
What if it's unduly burdensome for them, or they think it is?
Well, I don't think that the unduly burdensome argument was ever made necessarily, and that would require citation to a separate provision of the Open Records Act, which is 45-218E. That never happened here. And beyond that, the records that are requested in this case are Excel spreadsheets and PowerPoints that were shown at board meetings. So these documents, these records exist. It's just a matter of sending them out. There's no overly burdensome issue here in this case, Your Honor.
Well, I understand what your position is in this case, but your first statement was very broad, that they must provide it in the matter requested, regardless. So, is there a remedy if the agency believes that the requester's request of format is unduly burdensome, overly cumbersome for the agency?
Yes, Your Honor, they can cite KSA 45-218E, which was not cited in this case, and that is the statute that specifically refers to or empowers the agency to make that determination that it was unduly burdensome and deny the request on that basis. So I would amend my previous statement to the extent that if it is an overly burdensome request, then the agency would have that as a backstop under that specific provision.
Well, let me, I just want to get the facts kind of cleared up, because honestly, this phrasing of, native electronic format, there are times when people have asked for data to be put into an Excel spreadsheet with certain data limiters, and that's not what's at issue here, right? These are already existing Excel files and PowerPoint files, and maybe a Microsoft Word file or two, or are we just talking about these two?
I think we're talking about Excel and PowerPoint.
Okay, so that's that, but they're already created by the agency and they're just sitting there.
That's correct.
Okay.
They are records that are existing, and the requester has not asked the agency to create records.
Let me ask you this though. Okay, so it's an Excel PowerPoint, and just based on my limited knowledge here, in Excel, all right, so they were presented in a public meeting,
Correct.
right? And that's why they're KORA. And so, but there's metadata in those little blocks of the Excel spreadsheet.
Right.
Now that metadata was or was not, or is not subject to an Open Records Act.
Well, it is subject to the Open Records Act because the definition of a public record is any recorded information regardless of form. And so once that metadata appears in an electronic record that the agency has created, then regardless of form, it's a public record.
So an Excel file that where some cells are actually formulas and not real numbers. If the agency produces that as a paper record, then the public would not know what the formula is that went into the calculation that created what is only a number on a piece of paper.
Correct, Your Honor.
That's the whole thing about native format, because then you get the calculations.
That's correct, Your Honor.
Is there an additional right under the public records law that says that the person requesting the data after they get the Excel file should have the ability to process the data and the numbers, for example, to do statistical analysis, or even to simply take a cell or a column, I should say, and reorder it. So that, for example, if you had an Excel spreadsheet with all of the all the state employees of Kansas and what they're paid a year, but it's done alphabetically, but what you care about is who are the most highly paid. If you get it as an Excel sheet, you can just click the column and reorder, as opposed to having to re-enter the data if you're operating off of the piece. Are you saying that you have the right to be able to get the document as it exists at the agency, but so that you can do that kind of process?
Absolutely, Your Honor. The determining factor is in what format does it exist in the agency's possession. And once it exists in that agency's possession, the CORA provides that those records, regardless of form, they're not subject to any other provision for redaction or 45-21A, must be disclosed.
Counsel, isn't format a red herring in this case? We keep talking about format, but it strikes me that what we're actually talking about is whether this is a public record.
Well, I'd love to talk about just that, Your Honor. That'd be just fine.
So why is this entire case been framed through the lens of what format it has to be produced in? When, I mean, the real dispute here is, do we get the data?
Right.
And that question goes to, well, is this a public record? If the electronic version, I mean, if that is a public record subject to CORA, I guess I don't understand why we're arguing about format.
Well, I'm with you, Your Honor. I believe that this case is simpler than the arguments that have caused this case to come up to this level. And I think it really just comes down to KSA 45-217J1, which defines public record, which means any recorded, the statute word for word, public record means any recorded information, regardless of form, characteristics, or location, which is made, maintained, or kept by, or is in the possession of a public agency.
And you're saying, look, this electronic record, which we can shorthand as an Excel file, is a public record, and I want to see it.
That's what
correct. You're saying.
That's exactly correct, Your Honor.
And so it sounds like you're agreeing with me that, well, what format it comes in is just an irrelevant red herring question. I mean,
I guess I have to push back against that, Your Honor. What I think and in order to do that, I think it's important to review there's another controlling statute that deals with electronic records, and that's KSA 45-221 A16A and B. And in the petition for review, I cited an Attorney General opinion that's 88-152. And that analysis, there is no reason to deviate from that analysis. That analysis is a liberal construction of the open records law. And the key piece is where it says in 45-221A16B, it says that the thrust of the statute is that software programs do not have to be disclosed. That's the thrust of the statute. But then it also says that the agency is required to provide to the public the form in which the information can be made available using existing computer programs.
Okay.
It's that can be made available sentence, that provision that is so crucial and caused the Attorney General in this opinion to write that the above quoted statute implies that a public agency must, upon request, make duplications of records in any format which it has the capability of producing. And that's the rule that was established and adopted for decades until the
Let me just change my question slightly. It strikes me that if you quote, change the format, you've changed the record. I mean, it's a different public record at that point.
So I do agree with that, because in order to get the record that is actually in possession of the agency, that record is electronic, and we know that it is based on the facts in this case, then the open records law requires disclosure of that particular
Yeah,
record.
it's just, you make a copy of it, you burn it on a CD or you put it on a thumb drive and that's that.
Or email it, yes.
And so I guess, yeah, I think you've answered my question. It just strikes me that this
Well,
is simple.
So the Court of Appeals was wrong when it determined the CORA allowed the responsibility of determining the method and the manner of reproduction to the public agency. It's really, is it the requesters that has the right to determine the manner and the form of it, or is it the agency? That's basically, and then they went to, well, the legislature hasn't amended it like other states and the federal government has to include electronic copies, or even say it's the requester's desire to whatever form it is. That hasn't happened here. So how do you respond to what the Court of Appeals did in this case?
Your
Because
Honor.
that's really what they held. It's just
Well,
the hospital gets to decide, not you. Yeah.
Well, the reality is though, is that this legislature already has decided, because under the Court of Appeals ruling, the provision under 221A16B would just not exist. How about what happens to can be made available using existing computer programs? What happens to that provision if the
Can be that, and that's up to the agency to decide. And so why is that wrong?
Well, at that point, then what we can do, if we feel that it's necessary, if there is an ambiguous provision, whether there is a fair interpretation, whether there are multiple interpretations that can be fairly made, that's when we have ambiguity.
Well, I'm sorry to interrupt, but real quick, why is 221A16 even relevant to this case?
Because it sets forth the implication that that electronic records.
No, it's talking about, I'm sorry, but it's talking about information. And again, to me, this is important, and I may be completely off track and you can correct me, but I have understood this dispute as a dispute over records.
Right.
Certainly records contain information, but you want a specific record that you allege is in the possession of the public agency.
Correct.
You're not looking for information that is in a computer system, which can be made available through certain formats and it seems to me that actually favors your opponent.
Well, I will say that
You're asking for is a record.
that's correct. And I think that I will go back to how I tried to answer your question first, Your Honor, which is that the simplest explanation for why the record is available is simply because of the definition of public record. And beyond that, and to try to get to your point about mandatory disclosure, well, we have to look at 45-218 for that. 45-218A says that the public is entitled to records absent an exception. Absent an exception.
But
No.
isn't it true? They're not objecting to you getting the record. They're objecting to the form in which you get it. And they're saying, we get to decide whether you get paper or you get a thumb drive. We get to decide that. And you can have the formula. We'll give you the formulas. We'll give you the copy of the spreadsheet on a piece of paper. We'll give you all of this information. But they're saying we get to decide how we give it to you. And their basis for that is that the Freedom of Information Act specifically gave that right to the requester. And when our legislature wrote the Open Records Act, it left that out, implying that, now there's a dearth of information, but under one rule of statutory construction, there's significance to that. What's your best argument that that doesn't simply mean that it is the agency's right to decide how we give you that record?
Well, Your Honor, first of all, that language does not appear in the statute, of course, where the agency has the express authority to decide.
Right.
So neither of those express provisions are present.
But the previous one on which it was modeled, the Freedom of Information Act, did say the requester gets to decide.
Well, Your Honor, I'm going to push back on that too. The Kansas Open Records Act was modeled after the Kentucky Open Records Act. It was not modeled after the
It
Freedom of
also gave it to the
Information
requester, correct?
Act. I do not believe so. I don't, the Kentucky Open Records Act does not provide that to my knowledge. And that's what we have here is to the extent that if we're discussing whether or not the language has to be specifically in the statute or not, that creates ambiguity. And if we're going to go there, which I don't think we need to, because we have an open record or we have a public record, it's defined that way and it just needs to be disclosed. But if we are going to get into ambiguity, we don't have to search for the legislature's intent here. When there is ambiguity and the plain language could be interpreted different ways, we go to what the legislative intent is. And fortunately, under 45-216, we don't have to look. We know exactly what it is. And that is that the statute should be liberally construed and applied to promote the policy of openness. And so to the extent that this statute is ambiguous, the Attorney General opinions, these decades of opinions that with this well-reasoned analysis holds that ambiguity is resolved in favor of openness because that's what the legislature intended.
But they're giving you the information. Hey, we're wide open. You can have all of this information. We're just not going to give you a thumb drive.
Well, I mean, I'm going to go back to policy positions that I think are well stated in this original Attorney General's opinion. They cited a case from 1971. And that's it's from New Mexico Supreme Court, so certainly it's not binding. But I think this quote is incredibly instructive. Given that we have courts back in 1971 and the Attorney General's office in 1988 restating this, we are unable to understand why the right to inspect public records should not carry with it the benefits arising from improved methods and techniques of recording and utilizing the information contained in the records, so long as proper safeguards are exercised to their use, inspection, and safety. It's exactly what we have here. And the public policy that underpins CORA necessitates the disclosure of the records. And if that record in possession of the agency is in electronic format, then it must be disclosed under the Kansas Open Records Act.
It please the court. Good morning. My name is Quentin Templeton on behalf of Phillips County Hospital. Based on the plain language of the Kansas Open Records Act, excuse me, and this court's longstanding jurisprudence, this is not a close case. The Kansas Open Record Act does not contain a requester's right to dictate the form or the format that public records are produced. Justice Stiegel, I have to slightly disagree with some of your earlier questions. This isn't about whether or not they get access to the record. They can have the record, just as Justice Wilson was commenting.
Well, what is the record?
The
The
record,
public record at issue here.
well, there are a lot of them. After Ms. Rowe resigned from the Board of Trustees of Phillips County Hospital, she started sending multiple CORA requests to the hospital. There are Excel files she's asked for, there are PowerPoints, there are Word documents.
Why
There-
aren't those the records that are at issue?
Sure, those can be the records. The question is, what format does she receive those records in?
Well, but this gets to my fundamental conflict in this case. A record is a discrete thing. It's an object. It In the old fashioned world, it was this, it was something on a piece of paper. With computers, it can be much more complex, but it's still a tangible thing. It's not data, it's not information, it's a thing. It's a container that holds information in it. And that's what the statute makes publicly available, is the record. And so I feel like the arguments constantly are blurring the lines between information, data, and the record. And when you talking about formats, you're talking about information. If you're changing formats, you're saying, I'll give you the information, but I want to give it to you in a different format. That's a change in the record. You've moved from one discrete object to another discrete object. It's like two cars, and I'm going to take what's in the trunk of my car, and I'm going to put it in the trunk of this other car. But it strikes me that the statute, and this is a long-winded question, but it strikes me that the statute says, no, you got to give them the car. It's the record that's at issue.
And that's slightly incorrect.
Okay.
So Cora offers two basic rights. First is the right of inspection, and second, and it's a secondary right, is a right to abstracts or copies.
But aren't copies obtained for the purpose of inspection?
Presumably, sure.
Aren't you parsing that very, very finely?
No, actually not. If you look at the actual Cora as the legislature enacted it, they use inspection and copies very distinctly and in different ways, and they have different meanings.
So
And in-
are electronic copies different from hard copies?
I don't think so under Cora.
Well, why in 218, KSA 45-218, do they even refer to original copies?
The best answer I can offer is the fact that Cora was enacted in the early 1980s. I'll age myself, but it even predates
But
my
doesn't
birth,
that make
but-
the word copies ambiguous?
No,
If
I
it
don't.
can be a hard copy, which is different from an electronic copy, which is different from an original copy?
I don't think so, because for an example, my daughter, excuse me, has a Van Gogh painting in her room, but it's not a real Van Gogh. It's a copy of a Van Gogh, right? It's been printed off of a printer, despite what she thinks, despite what I might prefer having an actual Van Gogh, she has a copy. Everyone knows what a copy is. It is, if we look at Black's Law Dictionary, we look at Merriam-Webster, which are cases that, or are sources that this court turns to for interpretation. It's just a reproduction of the original document, which gets to Justice Stiegel's question, which is, we're not talking about the actual document. A requester never gets an actual document to take home with them. Now, Cora does provide the opportunity for the government agency discretion to give the actual document to the person, but we're always dealing with a reproduction of the original, which always necessarily means that the original electronic file stays with the government agency.
Why do you care?
It's a great question.
I mean, other than the fact that you don't like this requester,
Sure.
why do you care?
So that's the policy question, right? It's sort of the elephant in the room. A couple issues. Number one, that sort of policy determination, and we heard it in the first argument, is really left for the legislature. This court's decision or jurisprudence has always said, whether the legislature included a right or not in a statute is for the court to interpret, but the policy decision-making behind it, whether it was good drafting or not, is not for the court to make.
But the policy under all of the attorney general opinions before Cora was enacted said that an electronic record is discoverable and should be given at the request of the requester, right?
After Cora was enacted, I think you meant to
What?
say.
Well, I think there were attorney general opinions even before Cora that it was the requester who gets to decide the format.
The oldest attorney general opinion and analyzing Cora was in 88 that's been cited by both parties, and Cora was enacted before 1988. But the policy, we don't have to guess about. We don't have to read the legislative tea leaves. The legislature in 45-216 expressly stated what the public policy is, and it's a right to inspection. It's not a right to copies even.
Okay.
The
well,
legislature was very clear about that.
But the attorney general consistently said it was the requester who gets to decide and even in letters to legislators, and they didn't change the statute. So isn't there a presumption that that was okey dokey with them, that they left that blank in the statute?
There's not. As the court is well aware, Attorney General opinions are at best persuasive authority. The court routinely dismisses them, especially when the logic and the legal analysis is faulty. All of those prior Attorney General opinions are faulty legal analysis because they all imply the right in the Cora. They say that they're implying it based on the public policy of a liberal interpretation. But liberal interpretation is a rule, a canon of statutory interpretation. It requires a prerequisite of ambiguity.
And
But
to
somebody-
that point, to that point, Mr. Templeton, everything you're basing on, is that there's an absence of language allowing the requester to dictate the format. And so there's no ambiguity. But isn't it also true that there's an absence of language allowing the agency to dictate the format?
There is, and for,
Wouldn't- So I don't understand if there's also that absence of language.
why we get the benefit.
Right.
Right. So that's based on this court's own jurisprudence. Data tree is the most recent example. There, the court was analyzing whether or not the requester paid for redactions or the government agency. And what the court did is it actually looked at FOIA, which Cora was in part modeled off of, and the Kentucky Open Records Act, both of which, Justice Wilson, you're correct, do contain rights of requesters to dictate the format they receive documents in. And in Data Tree said that FOIA puts the burden of redaction, the cost of redaction onto the public agency. But because it's missing from Cora, and because the legislature is tasked with knowledge of those corollary statutes that they're using as influence for drafting our laws, its absence means the legislature intended to omit it. And
Right, but they went to statutory construction, which goes against your argument that it's the plain language, that we have no ambiguity. And so we don't have to go to statutory construction or 216A, which requires liberal construction.
that's right. And that's in direct response to your question, Justice Standridge, that if its absence, what does its absence mean? That's trying to divine the legislative intent. Then we have to follow this court's jurisprudence as to its absence and the corollary statutes. But you're exactly right. At the outset, there's no language within Cora that implies or that expressly gives a requester's right to dictate the method that they
But
receive their copies.
Why would it be logical if A, the person is entitled to the record, B, it is absolutely part of the record that the person is entitled to, C, that person has to pay for everything, including time of redaction, time that it takes to get the record. So D, why shouldn't the requester then logically be able to determine the format, since she has to pay for it, instead of the agency who may not like the requester and want to make it as expensive as possible?
Well, here, all of the records, I think the most expensive request she asked for was like $30, and none of them were paid for, including actual hard copies.
Did
that
you
she
ever
requested.
offer to give it to her in electronic format that you had available without adding anything to your records?
No, she was never offered the opportunity for an electronic format.
But that was what she asked for.
Well, not entirely. She did have a lot of requests that did ask for hard copies in addition to electronic version, and she never paid for those either.
I want to simplify this. There's an Excel file, spreadsheet. And as I understand your argument, you want to say, and that when that Excel file is requested, the agency has the discretion to decide not to just email the file to the person. It can print the file and hand over the paper, right?
Correct.
And so if you like the requester, you'll email it. And if you don't like the requester, you'll print it out because that's more burdensome to use the information.
No, I don't. That's where I disagree.
But you'd have that ability.
No, it would be based off the agency's policies and procedures, which the legislature has mandated that they enact.
Where is there a policy that says that they get to burden one requester and not burden another requester?
that presumes that they're going to produce the documents differently to different people. My point is that they have to follow their policy. So if their policy says we're going to produce electronic versions sometimes or all the time, they have to follow that policy. For example, this court's.
Was there that policy in existence prior to her request for those computer files?
The hospital's policy does not allow, it doesn't,
Is it written? Is it?
It's a written policy.
Is that a given fact that you
Yes.
had this policy?
It's in the
question
record.
is whether that policy then violates the open records law.
right, that could be the next analysis, but Phillips County's Cora policy mirrors in this respect, this court's own Cora policy, which the court has at Rule 160B subsection B2, which this court has approved and says that when a requester asks for electronic documents that are not in a court docket, that the Cora officer has the discretion to determine the format in which they're going to produce those. It's the court's own policy.
What is?
Let me-
I'm sorry, go ahead.
I'm struggling with just this basic concept of what is a copy under your formulation of how you read. So, you know, as a copy, to be a true copy must contain everything and it must look the same. I mean, if you have, going back to your daughter's, was it Van Gogh, print, it's not a copy of a Van Gogh if the lily pads are in the sky rather than on the bond. So if you produce it in a format where the metadata is not embedded and available, but maybe over here it's a separate, you know, we're going to give you a separate sheet of paper that has the formula on it. Or we're going to say, oh, look here, and you know, A1, we've got this information. It's different. It is not a true copy. So isn't the only way to do a true copy of, let's say, an Excel spreadsheet to actually provide an Excel spreadsheet in
No,
electronic form?
no, with 2 keystrokes, you can produce an Excel file with all of the formulas printed in it. It's not
But now
hard.
you're creating a
But
new
you're-
document.
different
It's not, it is the document unless the data, as Justice Stiegel's pointing out, the data is not part of the document. In which case, I'm not sure why she's entitled to the Excel spreadsheet at all. It's not part of the open record, but
What I'm saying is you would, if you print it out and you may in some format provide that metadata, but if you've printed it out, you've changed the document, haven't you?
no, because Cora was enacted in the early 1980s. We were always making copies of government documents.
But those,
Always.
those documents, typed on a typewriter didn't have metadata. I
Right,
mean, you
right.
know,
And now we
uh,
do. And the legislature has never gone in to address the metadata
It
question.
didn't need to, did it? Because it said you will give a copy. And,
Of-
and if that document has within it that metadata, isn't that a copy of that necessary to be produced?
It doesn't require, if the information itself is what the requester needs, right? So we're making, like, let's go back to the typewriter example. We're making a physical copy of the typewriter, of the typewritten page. And so if there's a line through it and it's typed above, that is reproduced on the copy. If we're able to, excuse me, print the Excel spreadsheet, we're able to print it with the formulas. We're able to produce, just like in civil litigation and in criminal litigation with electronic discovery through 6234, and we're able to produce all of this information. And she has, or the requester has that information that's inside the record, then it is a direct copy. It's an absolute replica. Actually, a replica of an Excel spreadsheet is a printed one without the formulas, because you can't see the formulas unless you start digging into it. But at the end of the day, it's far simpler than that. The legislature has never allowed the requester, regardless of what a record is, regardless of what a record contains, has never allowed a requester to dictate the format that they receive the documents back in.
That gets me to the one, I'm sorry,
Go ahead, go ahead.
that gets me to the one thing that's been bugging me a lot in reading all this material is you seem to argue that the agency benefits from silence statute. In other words, statute didn't tell you you have to do it, so therefore you don't have to do it. And that seems contrary to me to Stephan versus Harder. Because in that case, there were documents that commingled private data, confidential data with public expenditure of funds. And there was nothing in the law that existed at that time that said the agency had to redact the confidential part from the public expenditure part. And the court said the policy of this law is that the agency has to do that in order to promote disclosure and public, and public information. And so I don't think silence I don't see how silence as a matter of law helps the agency under this particular statutory scheme. So
Right.
what's your response to that?
Well, in this case, it is writing a right into the Cora that's not there, that the legislature. never-
Redaction didn't exist in the law at the time Stephan versus, does
Right.
now,
Right,
because they codified.
Right.
But it didn't then, and this court unanimously said that you have to do it in order to promote the policy behind open records law.
and I think the analysis in that case is that unredacted, the government information contained in the record is an open record. That information is obtainable. And so procedurally, the government agency can't just commingle data, government data with private information to bar people from accessing government documents. That makes sense. That makes logical sense. That really goes to the metadata question that is sort of kind of floating in the background of this case of, well, if we're going to go down the rabbit trail or the rabbit hole of metadata, where do we draw the line? What metadata is accessible?
Except that you're trying to use this silence, give you discretion to burden people who are asking for the disclosure of public information.
And
Regardless of whether you have a policy that existed before or after,
Right.
the policy you've enacted burdens the production process of the open records law.
burdens in
That's
the-
contrary to public policy from the introductory statements in the statute. I don't see any difference there.
burdens them in the sense that they can't get it electronically, so it's
Yeah.
manipulable.
Yeah.
Is
So
that
they can, so that they can, or just be able to use it conveniently on their computer or have it quickly, because you only have to click a button and email it to them and you're done, instead of having to produce copies and then say, oh, well, there's 500 pages here of this spreadsheet, so you owe us 25 cents a page. That's what you're saying you get to do under this law.
Well,
And that seems contrary to public policy, as stated by the legislature.
again, on the public policy angle, the public policy is the legislature expressly limited to the right to inspection, not copies. 45-216 is limited expressly just to the right of inspection, the public policy of Kansas. But as to the burden argument, it's sort of the larger public policy question, right? Of what's the risk? Why not just give it to them? And the issue is, what else is inside that document? If we open up this opportunity for the requester to get that, what metadata gets sent? How does an
You get
agency?
to litigate that document by document. If you've got secret attorney-client editing inside of a Word file, all you have to do is say, hey, in version 6 of this document, there's a bunch of comments in here by a lawyer, and that's not disclosable. So this gets redacted, or it gets, whatever the remedy is. But you don't create a blanket exclusion on the possibility that there may be something else out there.
Not on the possibility, on the fact that there's something else out there. So for example, if the court adopts this broad rule that anytime someone asks for a public record, you have to produce it in its native format, then someone could request this court's Word version of its opinions and could look at who edited the document, who was the last person to edit the document. They could ask for prior versions of the document if it's already been if the opinion itself has been publicly published, then the draft exception would no longer apply in 221. And that gets us down a rabbit hole of things the legislature never
Why
considered.
is that a rabbit hole? I mean, isn't that exactly how the Open Records Act is supposed to work?
It's
You
not,
say, I want a public record. And then the public agency says, well, this public record is not disclosable for the following reasons.
but there wouldn't,
Therefore, you don't get it.
there wouldn't be a basis to prevent disclosure of those draft opinions from the court. There wouldn't be an
Actually, I
exception
think
under
that's a
court.
There are
bad
quite a few
example.
exceptions that would apply. but-
Right.
But there's an exception that swallows your.
Yeah.
your-
Well, the exception that the court is in charge of drafting its own rules. And that exception, the court has said, we have the discretion to determine what format we're going to produce public records.
Let me
in.
ask my question about this word format that keeps coming up. It strikes me that we've dramatically broadened that word. When I hear format, that the requester doesn't have a right to dictate the format. To me, what that says is you can't dictate that you get this electronic document on a thumb drive. If we want to email it to you, we can. If we want to burn it on a CD, we can. If we want to put it on a thumb drive or whatever electronic, and that's the format. But we're talking about the same record. But when you use the word format, you're talking about actually changing the record. And this gets back to, I know Justice Luker's question about what is a copy. Let me ask the question this way. If this court disagrees with you that a printed version of the Excel spreadsheet is a legitimate copy, do you lose this case?
If a printed version of an Excel spreadsheet
It-
is a copy.
Yeah, your argument is that I can print an Excel spreadsheet and I have made a faithful copy.
Mhm.
That's your argument. If we disagree with that argument, do
Mhm.
you lose?
No, I don't think so.
Well, why not?
Because the legislature didn't give the requester the right to dictate how they receive the document. So it still would be the discretion of the agency.
To do what?
To produce a copy.
And
And, but that raises the second question, right? Which really isn't briefed in front of the district court. There are no experts to opine on this, but is a PDF of the Excel document or the PowerPoint or
let's
the Word
say,
document.
let's say,
a
I'll make
copy.
this as easy as I can. Let's say this court concludes, and this is hypothetical,
Sure.
that to make a true and faithful copy, it has to be a copy of the electronic document in electronic form.
In
do-
its native, like Excel
Well,
to
it's just a
Excel.
copy. It's you click and drag. I
Right,
want to make
right.
this as simple as possible.
Right.
If that's what copy means, do you lose this case?
Yes.
Okay.
Yes, to make sure that I'm answering the right question, that if the court holds that a copy of an Excel document means it has to be given to the requester in Excel, yes, we lose. Yes. Thank you.
I know you've got a lot to chew on there, but I want to follow up just. Can our opinion simply be limited to that Excel file is a record under the law and leave it for you all to fight about what's in the record?
I believe so, Your
Any
Honor.
other, is there any other, I know this is the one on interlocutory appeal, I think. Is there anything else in the case we need to decide other than that Excel file is actually a record? And so it is subject to disclosure under the law, under the open records law, and then you're into whether all the exceptions apply and all that business.
Yes, that's the position of my client, is that we are asking for a determination that in this example, the Excel spreadsheet is the record that must be disclosed.
The file. I mean,
Yeah, the file, yes.
whole thing that,
The .dox or
Yeah.
whatever,
Yeah.
yes. Right. Other than that, Your Honor, I just want, as I just have a few seconds, I'll just comment on one thing. There was some suggestion that the Open Records Act is only about inspection and not copies. Well, that of course would just totally dismiss each and every aspect of the law that goes through copies and all the procedures for how to get copies, and then the presumption of access that has the tradition of access that has been effectuated over these decades, and I would also just lastly say that even though the Open Records Act was enacted in the early 80s, these Attorney General opinions talk about the dissemination of electronic records, very early on. So the Cora is not limited to paper records. It was never limited to paper records. The definition of open records requires the disclosure of the file that the record exists in, for example, an Excel spreadsheet.
So is the word copies then ambiguous?
Absolutely. The word copies is ambiguous, and to the extent that it is, then that requires the statutory construction, which brings liberal construction into play.
Why are you saying it's ambiguous?
Well, the word copies is not defined, and every time the word, I guess that I'm just being deferential to the Court of Appeals. And the definition of ambiguity, which is, allows for different interpretations. I think that the definition of copies, for kind of the reasons that you all suggested in the questioning, copies has become a loaded term. Are copies electronic? Are they paper? So I do think it's ambiguous, but I also don't think that any of that really matters. What matters is not so much the word copies, but the word public record, and whether or not the Excel spreadsheet in this case falls into that definition. It does, and therefore it should be disclosed. Thank you.
Thank you to both counsel for your arguments in this matter. We will take this appeal under advisement.